Judgment in the matter of Wells versus Devani.
Lord Kitchin will explain the decision of the court.
Mr. Wells is a retired stockbroker's office administrator. In 2007, he and a builder completed the development of a block of 14 flats and put them on the market through a local estate agent. By the beginning of 2008, 6 of the flats had been sold and 1 was under offer, but 7 were still available. Mr. Wells was living in Andorra at the time and mentioned to one of his neighbours, Mr. Nicholson, that he was having trouble selling the remaining flats. Mr. Nicholson responded that he knew of a company that might be interested. Mr. Wells said he'd be very happy for Mr. Nicholson to make some inquiries. Mr. Nicholson then sent an email to Mr. Devani, an estate agent in Kilburn, telling him about the flats and giving him Mr. Wells's telephone number. Shortly afterwards, Mr. Devani made a telephone call to Mr. Wells. In the course of their conversation, Mr. Wells asked Mr. Devani about his fees, and Mr. Devani told him that his standard terms were 2% plus VAT. Mr. Devani then approached a housing trust, and after a meeting at the development site, which was attended by a representative of the trust, Mr. Wells and the builder, the trust agreed to buy the flats for £2.1 million. Mr. Devani telephoned Mr. Wells to tell him the good news, and later, on the same day, sent him an email stating again that his fees were 2% plus VAT and asking him for the name of his solicitors so that he could send them an invoice. Mr. Devani attached to that email his written terms of business, which provided that the commission would become payable on exchange of contracts with a purchaser. Mr. Wells refused to pay the commission, and after completion of the sale, Mr. Devani issued these proceedings in the Central London County Court. Mr. Devani claimed that he and Mr. Wells had made a binding agreement on the telephone when they first spoke. He had introduced Mr. Wells to a purchaser who had bought the flats, and so he was entitled to his commission. Mr. Wells responded that he was not obliged to pay for a number of reasons, 2 of which are relevant to this appeal. First, the terms of their agreement were too uncertain to amount to a binding contract because they never agreed the precise event which would entitle Mr. Devani to his commission. Secondly, Mr. Devani had failed to comply with his obligations under the Estate Agents Act of 1979 because he did not at the outset, or as soon as reasonably possible afterwards, expressly inform Mr. Wells of the event which would trigger his entitlement to commission. Nor did he provide that information in writing until after the introduction of the eventual purchaser. The trial judge accepted that Mr. Devani had only provided his written terms to Mr. Wells after the introduction of the eventual purchaser, and that his claim therefore depended on what had been agreed in their telephone conversation. He also recognised that, in that conversation, Mr. Devani had not specified the event which would trigger his entitlement to commission. But he held that the law would imply the minimum term which was needed, in a business sense, to make the contract work. Here, the least burdensome term, and the one which no one would have disputed had it been suggested by an onlooker, was that payment would become due on completion of the sale to a person Mr. Devani had introduced. Mr. Devani did introduce such a person, and so, on completion of the sale, he was entitled to his commission. The judge also found that Mr. Devani had failed to comply with his obligations under the 1979 Act for both of the reasons advanced by Mr. Wells. The judge decided that Mr. Devani was to blame for these failures and that it was appropriate to reduce his fee by 1/3, but not to deprive him of it altogether. The Court of Appeal, by a majority, disagreed with the judge on whether there was ever a binding agreement. It held that it was not permissible to imply a term into an agreement to make it complete. The trigger event for the obligation to pay commission was of critical importance, and so its identification was essential for the formation of a binding agreement. It had not been identified until after the introduction of the purchaser, and so the agreement was not enforceable. As for the 1979 Act, the Court of Appeal held unanimously that the judge had approached Mr. Devani's failures correctly in principle, but criticised aspects of his assessment. However, despite these criticisms, the court did not interfere with his conclusion. Mr. Devani has now appealed to the Supreme Court on the contract issue, and Mr. Wells has cross-appealed on the 1979 Act issues. This court holds unanimously that Mr. Devani's appeal must be allowed. Mr. Devani and Mr. Wells intended to create a legally binding relationship, and the only sensible interpretation of what they said to each other in their telephone conversation and the circumstances in which that conversation took place was that payment of the commission would become due on completion of the purchase and from the proceeds of sale. It was therefore not necessary to imply a term into the agreement. But had it been necessary, this court would have had no hesitation in doing so in order to make the agreement work and to give it practical coherence. The court would have been reading into the agreement that which its nature implicitly required. Contrary to the finding of the Court of Appeal, there is no general rule that it is not possible to imply a term into an agreement to render it sufficiently certain and complete to amount to a binding agreement. Indeed, it is possible to imply something which is so obvious that it goes without saying into anything, including something the law regards as no more than an offer. Further, if it is apparent that the parties intended to create legal relations, it may be permissible to imply a term to give the agreement such effectiveness as the parties must have intended. Accordingly, had this court not arrived at the trial judge's conclusion by a process of interpretation, it would have upheld him for the reasons he gave. Mr. Wells's cross-appeal is dismissed. The judge did make errors in his assessment, but they did not justify interfering with his conclusion, and the Court of Appeal was entitled so to hold.